Okay, let's dig into this. We've got a stack of filings here from a Florida Circuit Court case, state of Florida versus Stephan Michael Stearns. These are responses filed by the state just on June 10th, 2025. And they're pushing back against motions from the defense in, well, a capital felony case. So our mission, really, in this deep dive is to pull out the state's main arguments from these papers, give you a clearer picture of how Florida's legal procedures work and how they're being defended, especially, when the stakes are this high, a death penalty case.
Yeah, and right off the bat, what really jumps out is how strongly the state is defending its existing laws and procedures. You've got the defense challenging things, arguing they're unconstitutional or maybe weren't applied right, and the state is really digging deep into precedent to counter that.
Exactly. So the defense is challenging quite a few things. Let's start with two specific death penalty factors, the aggravating factors the state uses to argue for death. They're questioning the especially heinous, atrocious, or cruel factor, people call it HAC, and also the prior violent felony factor. For HAC, the defense basically says it's too vague, right?
Yeah.
And not applied the same way every time. They're pointing to some big U.S. Supreme Court cases.
Like Maynard and Godfrey. But here's where the state's argument gets, well, really specific. They argue the defense is kind of missing a key detail: the current Florida jury instruction for HAC. The Florida Supreme Court has already okayed this version, in cases like Hall and Randolph. And this instruction, it isn't vague like maybe older ones were. It actually defines the terms. It talks about acts being extremely wicked or outrageously wicked and vile, or specifically designed to inflict a high degree of pain.
Okay. So that definition is the crucial part.
Exactly. That's what makes it different from an older version the U.S. Supreme Court did strike down in Espinoza because, well, it lacked that clear definition. And the state also pushes back on that inconsistent application idea. They say you have to look at it from the victim's perspective, the surrounding circumstances, not just the method used to kill someone. They cite cases like McGirth and Famthere. It's a really key insight into how Florida interprets HAC.
Okay, so their argument is our current definition is legally sound.
Yeah.
Got it. What about the challenge to the prior violent felony factor? How do they respond to that?
Yeah, on that one, the state really leans hard on precedent, like a lot of precedent. They list out a whole string of U.S. and Florida Supreme Court cases, some going way back, including big ones like Profit. All these cases, they argue, have repeatedly said this factor, and Florida's death penalty law overall, are constitutional. Their main point is that this factor is fine, constitutionally speaking, when it's based on, prior convictions or even violent crimes committed at the same time as the main offense, as long as they were proven to a jury.
Right. Okay. Moving on from the factors. The defense also went after a specific court rule, Florida Rule of Criminal Procedure 3.202. This is the rule that lets the state bring in its own expert to examine a defendant, but only if the defense is planning to use mental health evidence as mitigation. Reasons to argue against the death penalty. The defense says this violates rights against self-incrimination, due process, things like that.
And if you think about the legal strategy here, the state's core argument, and they back this up with Florida Supreme Court cases like Kirsten Davis, is that this examination by their expert is just necessary. It's about leveling the playing field. They're saying, look, if the defense puts mental health on the table, the state has to have a fair shot at evaluating that evidence independently and maybe offering a rebuttal.
This makes sense.
Yeah, and they specifically reject the idea it violates self-incrimination, pointing out that Florida's rules, like Rule 3.230, actually have reciprocal discovery. Information flows both ways, often. It's about ensuring a fair fight, basically, when mental health becomes part of the defense case.
Got it. Okay, another big area was discovery. The defense was asking for a lot of information from the state, things like Brady material, evidence that could help the defendant, and info on potential jurors, too.
Right. And what's really interesting here is how consistent the state is in their response across these different requests. They admit they have obligations, absolutely, like handing over Brady stuff. But the recurring theme, citing cases like Medina and Counts, is that the defense needs to do its homework first. They call it due diligence. Basically, the defense has to try and find information themselves if it's publicly available, like checking court records online or public social media profiles.
So the state isn't required to do the defense's legwork for them.
That's their argument, yeah. If the info is out there publicly, the defense should look first. It kind of draws a line on how far the state's discovery duties go.
Okay, and lastly, there were these motions about jury procedures, things like juror pay, getting transcripts of jury selection in real time, questioning jurors individually about publicity or hardship, even how they handle jurors who just don't show up.
And the state's answers here pretty much stick to the established script The existing rules and laws. They point out juror pay, that's up to the legislature, real-time transcripts, generally required in death cases if it's possible under court rules, individual questioning or voir dire. Yeah, that's standard for pretrial publicity stuff, but for other things like hardship or views on the death penalty, it's more up to the judge's discretion. Cases like O'Neill and San Martin back that up.
And the jurors who don't respond.
Yeah, the state basically says sending someone out to personally serve them isn't required by law and probably isn't practical either. Fundamentally, they argue the current jury selection system is fine constitutionally. It doesn't violate the need for a fair cross-section of the community unless the defense can prove, actual systematic exclusion of a group. And that's a tough standard to meet based on cases like Duren and Jones.
So wrapping this up, what's the big takeaway for you following in this case?
Well, these filings really show the state digging in its heels, defending Florida's existing laws, court rules, and all that Supreme Court precedent against these defense challenges in a capital case. They're really focused on upholding the constitutionality of those death penalty factors, the rules around mental health evidence, and kind of the standard operating procedures for discovery and picking a jury.
Right. And it leaves you with a pretty important question to think about, doesn't it?
Yeah, definitely. How does this constant back and forth, this tension between a defendant's rights, their constitutional rights, and the state's need to, stick to its established legal framework, how does that whole dynamic shape the actual path to justice in these incredibly serious cases? Something to mull over.